And so my contribution really was just to highlight that point. Thank you, Mr Chair.
Charles Chevelle.
Thank you, Mr Chairman. Mr Chairman, it's been interesting to hear the various contributions in this debate on Part 1. I'd like to just begin by acknowledging the Green member, Julianne Genter, and to thank her for her party's expression of support for my supplementary order paper. Just to pick up some of the points that have occurred in the debate to date, the first speaker for the government side talked about why this legislation is important from the point of view of restoring the independence of the senior bar. But we've never really heard how that is to be brought about by this legislation. We've never really heard how the legislation creating the status of senior counsel and permitting lawyers who practice in firms in New Zealand and others from being appointed to senior status threatens the independence of the bar. And here's the point, sir. All lawyers in New Zealand, be they barristers or barristers and solicitors or solicitors only, are subject to the same set of ethical obligations. And that is a high set, or the bar is set high on those standards. It doesn't matter whether one is practising at the bar solely or in a firm. The same rules about conflicts of interest apply. The same rules about whether or not it is possible or required to disclose a matter to a client apply. And so this old-fashioned contention that somehow restoring QCs in the way that this bill would do preserves or enhances or restores the independence of the most senior of our lawyers by restricting the appointment to barristers only has never been proved. There's never even been an explanation of that point from the government and its sponsors. It is wrong. And the reason I suspect that it is advanced is because it's easier than saying, well, we want this because it's a nice way to preserve our monopoly. That's really all that restricting appointment to senior barristers to the rank of QC will do. It will, as my colleague Leanne Dalzale say, from the moment of appointment enable them to just charge a lot more because they have been recognised in this way. Now, sir, the supplementary order paper that I've put forward does something important. It preserves the independent appointments procedure that currently exists for senior counsel. Look, we accept the government has the numbers to do this, to put QCs back into the system. What we're saying is, would government members not at least consider with an open mind the benefits of keeping a bit of sunshine on the process? Now, Jackie Blue and Katrina Shanks and others will be interested in this little anecdote that I'm about to relate. Recently, a friend of mine opened a chambers. He's a barrister. He's a good barrister. He's in a good chambers. And it was a nice thing to be able to go and celebrate with them. A number of other barristers came up to me during the course of the evening and said to me, we're really concerned about two aspects of this legislation. First of all, the restriction of the rank and the appointment back to barristers rather than to include practitioners in a firm. And we're worried about going back to an old murky procedure, the old boys network. Guess what gender these lawyers were? They were my female colleagues at the bar. And they said these things for this reason. It's much easier as a woman practising in the law to practice in a firm. Partly, if you have ambitions to have a child, that's because firms tend to have provisions around parental leave and around flexibility of work conditions if people want to try to combine family life with practice in a firm. The bar doesn't have that, and here's why. If you're going to be at the bar, you have to be what we would call, in ordinary parlance, an independent contractor. You can't be employed by anybody. You can't be in a partnership. You can't form a safety net or pool your risk. you have to be on your own in terms of employment status. And so that's why we've had so few, Mr Chairman, that's why we've had so few senior women in the profession reaching the utmost heights of SC or QCdom, even though now for probably 10 or 15 years, fully 50% of the graduates from our law schools have been women. It's really, really hard. So to restrict the status to barrister's sole, and to go back to some murky appointments procedure where nobody really knows how you become a barrister, it just has something to do with being on good terms with the Attorney General or the Solicitor General or the President of the Law Society or a senior judge, is going to inevitably have the effect that fewer women are going to get appointed to the status. We're going to have less diversity at the top end of our legal profession. And all I'm saying to members opposite is, if you think that those are bad ideas, then you can let Chris Finlayson have the victory of going back to the title of QCs. Even if you believe that that's a good thing, you can have it. But by adopting my supplementary order paper, what you could also do is preserve the openness of appointment procedures that we now have. And so you could actually help keep a bit of diversity in the senior levels of the bar, rather than going back to the bad old days of the old boys network, which will inevitably happen if the legislation passes in its current form. And don't take my word for it, take the word of the people who came up to me recently at the event that I've described to you, and listen to the fears that they expressed. Dr. Blue said, well, you know, this isn't a bad thing because the bar asked for it, the Bar Association asked for it. With respect, Dr. Blue, that's a bit like senior specialists in a particular medical profession saying, we'd quite like not to have to be subject to a particular disciplinary regime because it restricts our independence and our ability to apply best practice in our particular field. Of course, the union, the professional association representing a particular group of people, are going to want what's best for that group of people. That's their job. That's what they're doing when they put that sort of submission forward. It doesn't mean it's in the public interest. It doesn't mean that they're thinking about how best to preserve diversity at the most senior levels of our profession. It doesn't mean that they're thinking, how do we ensure that the best public confidence exists in our senior lawyers by ensuring that they are appointed openly to a particular status, and that they are appointed from as wide a background in the profession as possible, rather than restricting them to the bar where, just by economics, only a certain type of practitioner in New Zealand to date in general has been able to flourish. And so that's really all I'm trying to ask members in the House to think about. As I say, I thank one party in particular for having taken on board this idea. I hope others will consider it with an open mind. And finally, sir, I'd just like to try to make a bit of an appeal to logic. We've talked about how the bill will generally revert to a system where only barristers can be made Queen's Counsel. And yet there's a provision in clause 119C, I think it is, that says, but none of that all really matters, because the royal prerogative as to the appointment of Queen's Counsel is preserved by this legislation. That's the provision under which Paul East QC had himself appointed a Queen's Counsel before he went off to argue the French atmospheric testing case in the World Court. Presumably that's the clause upon which will be relied to make Mr Finlayson a Queen's Counsel, because under the statutory procedures he isn't practising as a barrister. He's a member of this House, and he is excluded, as far as I can see, by the provisions of the bill. So even under the legislation, the government's got a, well, we can do whatever we like clause, and to me that undermines the logic of the position that Mr McIndoe took earlier, that somehow this legislation is vital to restoring the independence of the senior bar. Well, it can't be if the government's still going to have an out clause allowing it to invoke the royal prerogative at any time, which means that the Attorney General can go off and see the Governor General at any stage and say, sir, I advise you to appoint the following people to the rank, whether or not their solicitors, whether or not they're working at a senior level in local government, whether or not they're the chief legal advisor in a particular government entity, whether or not they're a sitting MP. And that's the flaw of this bill, sir, and it's why I'm trying to get some better sense into it.
There are two sets of amendments. I'll put the Minister's amendments first. So the question is that the Minister's amendment set out on SOP number 136 be agreed to. Those of that opinion will say aye.
Aye.
Contrary, no. Aye. The ayes have it.
Ayes
party vote. The clerk will conduct a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 opposed.
New Zealand First.
8 votes opposed.
Maori Party.
3 votes in favour.
Mana.
Sorry, 1 vote opposed.
ACT New Zealand.
1 vote in favour.
United Future.
1 vote in favour.
The ayes are 64, the noes are 57. The amendments are agreed to. We move to Charles Cheval's typescript amendments, deleting clause 4B and amending clause 6, new section 119C by adding new subsection 3. The question is that Charles Cheval's amendments be agreed to. Those of that opinion will say aye. Aye. Contrary, no. No. Noes have it. A party vote. The clerk will conduct a party vote.
New Zealand National.
59 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party.
14 in favour.
New Zealand First.
8 votes in favour.
Maori Party.
3 votes opposed.
Mana.
1 in favour.
ACT New Zealand.
1 vote opposed.
United Future.
1 opposed.
Ayes 57, noes 64. The amendments are not agreed to. The question is that Part 1, as amended, stand part. Those of that opinion will say aye. Aye. Contrary, no. Aye. The ayes have it. Party vote. The clerk will conduct a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 opposed.
New Zealand First.
8 votes opposed.
Maori Party.
3 votes in favour.
Mana.
1 opposed.
ACT New Zealand.
1 in favour.
United Future.
1 in favour.
The ayes are 64, the noes are 57. Part 1 as amended will stand part. The question now is that Part 2 stand part. Charles.